back, America. I'm Hugh Hewitt, joined by Charles C.W. Cooke, senior writer for National Review. Charles is one of the few people I like to talk to about common law who is not a lawyer because he actually reads the Constitution, understands it. But I want to talk to you about international constitutional law, Charles. Have you been following the debate over the Israeli Supreme Court, its powers, its overreach, and the attempt to reform it?
Yes, I'm not an expert on it, I will say up front, but it seems to me that this is an interesting question precisely because, unlike in the United States, we don't have in Israel a court that is interpreting a constitution that sits above the rest of the law, and so some of its behavior seems usurpatory to me.
I bring it up because the headline in the Times of Israel at this hour is, High Court orders the government to explain why it's not launching an October 7 state inquiry. Now, that's just a naked assertion of power by a court that does not rest upon a written or an unwritten constitution. What do you think that represents?
Well, if I were Israeli, I'd be very annoyed by that because it circumvents the democratic process. We see something similar in England, where Parliament created what they call the Supreme Court, but is nevertheless subordinate to Parliament, which then presumes to tell Parliament in some circumstances what to do. This is often a problem. It's a problem in Israel to a greater extent than that, because the court seems to have taken upon itself the role of almost superintending the political process. You know, I think this is one of the things some people sometimes misunderstand about the United States. The Supreme Court only has power because the Constitution was ratified by the people, as were all of the amendments. If it weren't, it would have no position within our democratic republic whatsoever. So I have a problem with that in Israel. I have a problem with that in Britain. I don't have a problem with it in America, unless, as sometimes happens, the court in America decides to act outside of the law itself.
I agree. Now, this week, James Carville and others said it's time to pack the Supreme Court, do what you got to do, move it up, 12, 13, 14. To me, that's the end of the rule of law. I wanted to know what you think about packing the Supreme Court and about the argument that I make. The last time the court number moved, it was from 10 to 9, I believe, in 1867 or 1868. The 14th Amendment was ratified just after that. But I believe there's an argument that the 14th Amendment prohibits court packing above 10. What do you think about that?
Well, I think court packing would be a disaster. I think it would, as you say, be the end of the rule of law. It would also be the end of judicial review, which would be a big problem in a country that has a written constitution. The number, as critics of the Supreme Court, critics who are wrong, by the way, this is probably the best Supreme Court we've had in 80 years. The critics of the Supreme Court often say, well, the 9 number is not entrenched in the Constitution, and that's true. But there are times in American history at which traditions that have obtained since the beginning, or for a very long time, ought to be respected. I'm not talking here about violations of the Constitution becoming entrenched and thereby accepted. I'm talking about, for example, the tradition of presidents not running for a third term. That wasn't in the Constitution either, but it was very important to our system. And so in the 1940s, Congress got together and said, we're going to make this a rule rather than an expectation, after Franklin Roosevelt, before him Woodrow Wilson, tried but failed, and Grant, I think, flirted with it in the 19th century. I think the same thing ought to happen here with the Supreme Court. I think that the country ought to look at the current political situation, look at the number of people talking about court packing, and say, look, this has been a stable part of our system for 150 plus years. We will now make it mandatory and pass an amendment that limits the court to 9.
I would like to see that, but I would also like the argument to be made. Substantive due process enshrines as fundamental those rights which are anchored deep in American history and tradition. And Justice Scalia began that argument. It's been carried forward by Justices Alito, Thomas, Barrett, Kavanaugh, Roberts. Even Justice Kagan occasionally acknowledges it. I think a radical departure, anything above 10, you might want to add 1, that's the highest it's ever been, would shatter faith in the rule of law, and I think bring the republic perilously close to its end. Am I an alarmist?
No, you're not an alarmist. I'd be opposed to adding 1 for the record, because then you would get a bunch of ties. And I think 9 is a much better number. I think it's much better to have 5-4. When Scalia died and the court proceeded for a while without a 9th justice, the bad lower court decisions that would have been overturned by the Supreme Court often remain, just because the court was deadlocked. So if you're going to add 1, you should add 2. But you shouldn't add any, because there is no crisis at the Supreme Court. The Supreme Court is doing its job in a professional manner. The fact that it is originalist is a good thing, not a bad thing. Even if you don't think it's a good thing, what we have is a Supreme Court that has a slightly different approach than the one that it had before, not a wholesale abdication of its role within the American system. So, yeah, I think it would be a catastrophe. I think it would lead, as I say, not only to the dissolution of the rule of law, but effectively to the end of the written constitution, because if you can't enforce a constitution as law, then it's just a guidebook.
That's it, and it would be disastrous for property rights and everything else. Now, I want to move from the highest court to the district court in Texas. 3-judge district court threw out the redrawn maps that were partisan, as every redistricting is, not unconstitutional, but 2 judges said they used race inappropriately. Jerry Smith, the dissenter, filed his dissent today. It's 100-plus pages, and boy, is he mad. He's spitting nails because he thinks the other 2 gamed him. What do you make of this, and do you expect the Supreme Court to take it up, reverse it, and leave Texas with its maps as the Texas legislators drew them?
Well, we're in the middle of a redistricting fight. Neither side is right or wrong in the sense that this is a political question.
Correct.
But it is absurd for figures such as Gavin Newsom to insist that when his side does redistricting, it's good for the Republic, but when Republicans do redistricting, it's a threat to democracy. This is a tit-for-tat game now. And I think it's bizarre that this court has intervened and ruled that Texas's map must be thrown out and replaced with the 2021 map. Now, the dissent you mentioned, I thought was a little bit hot. If Sonia Sotomayor had written some of those sentences, they would have annoyed me because they don't betray judicial temperament. But he is right. The game that has been played here does seem very fishy indeed, including the timing of this. And he points out that they waited until he was away, and they didn't give him time to write his dissent. They said that they had to push this right now. The timing of it's important because of the way that it intersects with the elections and the registrations themselves. So I think this is a big problem. I do expect the court to pick it up. I mean, I think we're in a very strange situation with the whole area, Hugh, because we've now reached the point at which if we don't gerrymander in a particular way, then it's illegal. And if we do gerrymander in a particular way, then it's illegal. And both of them are held to be racist. So I think eventually the court is going to have to essentially extend its prior declaration, which is that this is an intrinsically political process and therefore cannot be touched judicially unless there is a prima facie case for racism.
Exactly the correct answer. One person, one vote. We go with Reynolds v. Sims, Baker v. Carr, absolutely. But it's a political process, and I hope the Supreme Court acts expeditiously to reverse the district court. Judge Smith was hot, but he got rolled. And that's not the way courts are supposed to operate. Charles C.W. Cooke, follow him on X at Charles C.W. Cooke. Listen to his podcast, which goes by the name of Charles C.W. Cooke, and listen to him on the Editors at National Review Podcast as well. Stay tuned.